The pen was still in my hand when my brother's wife started laughing. Not quietly. Not the polite, restrained kind of laughter you perform in an attorney's office. She actually laughed, head back, shoulders shaking, the way someone does when they've been holding something in for a very long time and finally get to let it out. My brother put his arm around her and pressed his mouth against her temple, and I watched them from across the conference table while the notary was still gathering her seal and her stamp and her professional indifference. I had just signed my name to a document that transferred my mother's estate. The house in Glendale, the investment accounts, the small parcel of land she'd held in trust since before I was born, entirely to my brother. They thought I had lost. I knew something they didn't. I should back up, because the moment in that conference room is the end of a story that started roughly 18 months earlier, and the beginning doesn't look like anything dramatic. It looks like a hospital parking garage on a Wednesday afternoon in November. Fluorescent lights flickering over wet concrete. My phone showing 17 missed calls from a number I didn't recognize, and my hand shaking slightly as I pressed call back. My mother had collapsed at the dry cleaners 2 blocks from her house. She was 63. She had high blood pressure she managed carefully and a heart that her cardiologist had described, at her last checkup, as performing adequately for a woman her age. Adequately. She used to repeat that word at dinner and laugh. She had a sense of humor about her own body that I found both admirable and quietly terrifying. The stroke was moderate, which is a word that sounds gentle until you understand what it means in practice. It means she could speak, but sometimes the words came out in the wrong order. It means she could walk but needed someone beside her on the stairs. It means the woman who had spent 30 years running a small accounting firm out of a converted Victorian in Pasadena now needed help opening child-proof medication bottles and remembering which pill was which. I am a paralegal. I have been one for 9 years, working primarily in estate and probate law, which means I spend my professional life watching families navigate the paperwork of loss. I know what the documents say and what they don't say. I know which silences in a trust agreement are intentional and which are oversights. I know that the people who draft these things carefully and the people who read them carefully are rarely the same people, and that the gap between those two groups is where most of the damage happens. I moved back into my mother's house 6 weeks after the stroke. I gave notice on my apartment in Koreatown, a studio I had been unreasonably proud of, packed everything into a storage unit in Alhambra, and set up in my childhood bedroom with a second-hand desk and a baby monitor pointed at the hallway so I could hear if she needed something in the night. My brother did not move back. My brother lived 40 minutes away in Thousand Oaks with his wife Sherry and their 2 golden retrievers and a renovation project that seemed, based on his social media, to be perpetually mid-kitchen. He visited on the occasional Sunday. He brought pastries from a bakery in their neighborhood and set them on the counter and talked about traffic on the 1-1 and left within 2 hours, usually citing something related to the dogs or Sherry's family obligations. He was not unkind during these visits. He was something more frustrating than unkind. He was comfortable. What I didn't understand then was that he was also watching. The inheritance question surfaced for the first time about 4 months after I moved in. My mother had a good attorney, a woman named Ms. Everett, who had drafted her original trust with the meticulous specificity of someone who had seen exactly what happens when documents are imprecise. The trust divided everything equally between my brother and me. It had been that way for years. There was nothing complicated about it. My brother called me on a Tuesday evening while I was making dinner. He started with logistics. How was Mom? Had her occupational therapist updated the at-home exercise program? Were the prescriptions being refilled on schedule? He knew the answers to none of these questions because he had not been involved in any of them. I answered patiently. Then he said, almost as an aside, that he and Sherry had been talking about the house. Not in a threatening way, he said. Just practically. Just thinking ahead. He explained that they had looked into the property tax situation and found some concerning information. That the house had a complicated history with a lien from a contractor dispute my mother had never fully resolved. That the carrying costs, insurance, upkeep, property taxes were going to create a significant liability for whoever inherited it. that he had spoken with a financial advisor, someone Sherry's family used, who had strongly suggested that the cleanest solution would be for me to consider stepping back from my share. He said this the way people say things they've rehearsed, smoothly, quickly, with the particular rhythm of someone who has anticipated every possible response. I said I would think about it. I did not think about it. I went back to the kitchen and stood over the stove and understood that something had shifted and that I needed to pay attention in a different way than I had been. The documents started arriving 3 days later. My brother emailed them. PDFs, scanned at an angle that made some of the numbers slightly blurry, forwarded from an address I didn't recognize with a domain that looked almost, but not quite like a county assessor's office. The lien figures were large. The tax arrears were alarming. There was a column of highlighted numbers in red that seemed designed to suggest catastrophe, the visual language of financial crisis performed for an audience. I work in estate law. I read documents for a living. I printed everything out on a Saturday morning and went through it with a highlighter and a legal pad and a second cup of coffee. By the time I finished the first pass, I had 6 questions. By the end of the second pass, I had identified 2 figures that didn't correspond to anything in the public record. One citation to a tax period that predated my mother's ownership of the property, and one lien document that referenced a contractor company I could not locate in any California business registry. I texted my friend Deb, who had worked in title insurance for 11 years before moving to a real estate law firm in Burbank. I sent her photos of the documents. She called me back in 20 minutes. She said, and I will remember this exactly, "Whoever made these was counting on you not to look too closely." I started looking closely. The pressure escalated in the way pressure escalates when the people applying it realize their first approach isn't working. My brother's calls became more frequent. Sherry began sending texts, a thing she had never done before, friendly at first, then edged with something harder to name. She mentioned that they had consulted with an attorney about the estate. She mentioned that the attorney had raised some concerns about the management of my mother's assets during the period I had been living in the house. She used the phrase, "questions of fiduciary responsibility," in a text message with the confidence of someone who has just learned a new phrase and is not yet sure how sharp it is. I understood what they were doing. They were building an alternate story. One in which I was not the person who had upended her life to care for our mother, but a person who had positioned herself for access to assets. It was a reframe so audacious it almost worked as a strategy, the way very bold lies sometimes do. I spent 2 days being quietly furious about it, and then I stopped being furious and started being methodical. I purchased a small digital voice recorder at an electronics store on Colorado Boulevard. I am not going to describe the brand or the model because that's not the point. The point is that I tested it in my car 3 times before I was satisfied with the audio quality. And then I placed it in the interior pocket of the cardigan I wore to family dinners and left it there. I called my brother and suggested we meet in person to discuss the estate before I made any decisions. I said I wanted to understand the full picture. He agreed immediately. People who believe they've already won tend to agree to things immediately. We met at a restaurant in Monrovia, a place with good lighting and leather booths and enough ambient noise to feel private without actually being private. I ordered iced tea. I pressed record before the menus arrived. I asked, with careful and genuine-sounding neutrality, what would happen if I decided to retain my share of the estate and work through any tax liabilities directly with the county. I asked it the way someone asks who is worried and uncertain and slightly in over her head. I asked it well. My brother's response was patient and measured for approximately 90 seconds. Then Sherry leaned forward and the patience evaporated. She explained that if I chose not to cooperate, they had documentation suggesting I had been using my position in the house to influence my mother's financial decisions. She explained that their attorney was prepared to file a petition questioning the validity of my mother's current trust on grounds of undue influence. She used the word complicate several times in the way people use it when they mean destroy. My brother added that the legal process would be expensive and public, and that I would likely lose my job, given that questions of fiduciary misconduct tend to follow people in the legal field. He said all of this in the tone of someone delivering bad news reluctantly, which is a specific kind of dishonesty I find harder to forgive than ordinary aggression. I thanked them for their honesty. I said I needed a few more days to think. I drove home and sat in my mother's kitchen and listened to the recording twice, taking notes in the margins of a legal pad, and then I made an appointment with Ms. Everett for the following Thursday. What I had not told my brother, what I had not told anyone, was that Ms. Everett had reached out to me 6 weeks earlier about a codicil my mother had added to her trust shortly after the stroke. My mother was still cognitively sharp. The stroke had affected her language processing in her left side, not her judgment, and she had asked Miss Everett to add a provision that I had not known existed until Miss Everett called. The provision was straightforward in the way that truly careful legal drafting is straightforward. Any beneficiary who attempted to obtain another beneficiary's share through fraud, misrepresentation, or coercion would forfeit their own claim to the estate entirely. Miss Everett had suggested the language after a client in a similar situation years earlier. My mother had read it, asked 2 clarifying questions, and signed it without hesitation. I did not know, sitting in that restaurant listening to Sherry explain how she intended to dismantle my life, that the codicil existed. My mother had not told me. Miss Everett had called to inform me only after she noticed my brother had begun making inquiries about the trust through a separate attorney. She thought I should know. She didn't tell me what to do with the information. She didn't need to. At my Thursday appointment, I brought the recording. I brought my printed documents with the annotated discrepancies. I brought Deb's written assessment of the lien irregularities, which she had put on firm letterhead as a professional courtesy. Ms. Everett listened to the recording twice. She made notes. She did not react in any visible way, which is a quality I have always respected in her. She said she would need a few days to prepare the documentation correctly. The estate attorney my brother had hired, a man named Mr. Hollis, who had a website that described him as aggressively client-focused, had scheduled the signing for a Tuesday morning. My brother had positioned it as a formality, something to handle cleanly before my mother's next medical review. He had arranged for the notary. He had prepared the waiver. He had not told me, but I already knew, that the waiver was the entire point. I arrived 8 minutes early. I wore the cardigan. I sat across the table from Mr. Hollis, and my brother and Sherry and I performed very carefully the role of a woman who has thought about this a great deal and arrived at a reluctant decision. I asked questions whose answers I already knew. I asked Mr. Hollis whether I would be personally liable for the tax arrears if I declined to sign. I asked it with a slight hesitation, with the specific quality of uncertainty that comes from not knowing whether you're doing the right thing. Mr. Hollis answered. My brother added emphasis. Sherry confirmed details, loudly, specifically, on the record, on the recording. Then I picked up the pen and signed. My brother's shoulders dropped about 2 inches. That's not an exaggeration. I watched it happen, that particular physical release of a person who has been holding tension for a long time and suddenly doesn't need to anymore. Sherry reached over and touched his hand. Mr. Hollis began gathering documents. I excused myself to use the restroom. In the hallway outside the conference room, I had approximately 5 minutes. I used them to upload the audio file to the secure client portal Ms. Everett had set up for exactly this purpose, along with the annotated lien documents and Deb's assessment. I forwarded confirmation to Ms. Everett's direct email. I sent a copy of the full recording to my own attorney, a woman I had worked with briefly 3 years earlier who had agreed after a 30-minute phone call the previous week to be available on standby. By the time I walked back into the conference room to collect my bag, the documentation had been received and time-stamped. I thanked Mr. Hollis for his time. I told my brother I hoped this would make things easier for everyone. I meant it, actually, in a way that had nothing to do with generosity. My brother's phone rang as I was pushing through the lobby door. I know this because I turned back to hold the door for a woman with a stroller, and I saw him through the glass, phone pressed to his ear, his expression doing something I had never seen it do before. Miss Everett had moved faster than I expected. Mr. Hollis was apparently already receiving calls from her office. My brother turned and looked through the glass at me standing in the morning light, and I understood, in that moment, what the previous 18 months had actually been about. Not the house, not the money, not even the estate, It was about whether I had been paying attention. The legal process took 4 months. The waiver was set aside on the basis of documented coercion, the recording, the fabricated lien documents, Deb's professional assessment, and the time-stamped submission to Ms. Bittman's. Everett's portal collectively made the case with the kind of completeness that doesn't leave much room for counter-argument. The codicil activated as my mother's attorney had always intended it to. My brother's claim was forfeited under the terms of the trust he had spent 18 months trying to manipulate. Mr. Hollis received a formal inquiry from the California State Bar regarding his role in the process. I don't know how that resolved. I didn't follow it. My mother knew what had happened. I told her one afternoon in the kitchen, sitting across from her at the table where we had eaten 10,000 meals, and she listened with the careful attention she brings to everything now. The stroke made her slower, but it also made her more precise, like it burned away some unnecessary speed. When I finished, she was quiet for a long moment. Then she said in the slightly rearranged syntax that is hers now, "I thought you would figure it out. You always read the fine print." She was right. I always have. I want to be honest about what the aftermath actually felt like because I think the story is easy to read as a victory, and I'm not sure that's accurate. My brother and I have not spoken since the hearing. That's not a temporary silence. It has the quality of something permanent. I grew up with him. I shared a back seat with him on long drives through the desert. I know what he sounds like when he's actually laughing versus when he's performing it. The version of him that sat across that conference table from me is not a stranger I can dismiss. It is a person I loved for 30-some years who made a series of choices I cannot unknow. That's not triumph. That's a specific kind of loss I'm still learning the shape of. I am back in my own apartment now. A different one, 2 bedrooms this time, close enough to my mother that I can be there in 20 minutes when she needs me, and far enough that we both have room. I have a desk by the window and a coffee maker I actually like, and a storage unit that I've mostly unpacked. I am seeing a therapist who told me in our 3rd session that it is possible to grieve a relationship and also understand clearly that ending it was necessary, that those 2 things do not cancel each other out. I have found that useful. I still do the work I've always done. I still sit with families in the worst moments of their administrative lives and help them find the language for what they're going through. I am better at it now than I was before, which is the only honest silver lining I can offer. What I keep returning to, though, is a smaller thing. It's the moment in the hallway outside that conference room. 5 minutes, maybe less, just me and my phone and the documents and the decision I'd already made. Nobody was watching. There was no audience for it. I uploaded the files and straightened my jacket and walked back through the door, and nobody in that room knew that anything had changed. I had spent 18 months being useful in ways that were invisible. The caregiving, the medication schedules, the insurance appeals, the 2 a.m. checks on my mother's breathing. None of it was witnessed in any meaningful way by the people who most needed to understand its cost. I had been present in all the ways that don't photograph well, and absent from all the celebrations where my brother and his wife were very visible. What I know now, that I'm not sure I knew before, is that invisible work still leaves evidence. Documentation trails exist whether or not anyone is looking at them. I am a paralegal. I spent 9 years building cases for other people's most important moments. It did not occur to me, until it needed to, that I could build one for my own. If you are reading this and you recognize something in it, the slow reframe of your presence as a burden or a threat, the documents that arrive at convenient moments, the urgency that seems calibrated rather than genuine, I am not going to tell you what to do. I'm not in a position to, but I will tell you this: check the numbers, find someone who knows how to read what you're being handed. The people who constructed the story they gave you were counting on you to accept it. They were counting on exhaustion and grief and the particular vulnerability of loving someone who is sick. Don't be too tired to look closely. I almost was. Almost. I've thought a lot about what actually happened in that conference room. Not the legal outcome, not the forfeiture clause, not the 4 months of proceedings that followed. I mean the smaller thing. The moment I picked up the pen knowing exactly what I was doing, and the moment my brother's shoulders dropped 2 inches because he thought it was over. He had spent 18 months constructing a version of me that was convenient for him. Someone too exhausted to read carefully, someone too emotionally raw from caregiving to check figures. Someone who would accept a folder full of highlighted red numbers because grief makes people want things to be simple, and he was offering simple. What he didn't account for was that I had spent 9 years building documentation trails for other people. That the same habits I brought to work every morning, checking citations, cross-referencing public records, asking why a number doesn't match, don't turn off when I walk out the door. He saw a grieving sister. He didn't see what she did for a living. That's the part I keep returning to. Not the recording, not the submission to Mr. Says Everett's portal, not even my mother's quiet, "I thought you would figure it out." I keep returning to the gap between who he believed I was and who I actually was. He built his entire plan around a version of me that required me to be less capable than I am, and I think that's the most honest thing I can say about why it failed. There is a version of this story, though, where exhaustion wins. Where I don't call Deb on a Saturday morning. Where I look at the blurry PDFs and decide it's too much, that fighting it would cost more than accepting it, that sometimes you just absorb the loss and move forward. I almost was that version of myself. There were nights in my mother's house, 2 a.m., checking her breathing through the baby monitor, where I understood completely how a person gets too tired to protect themselves. I don't think intelligence alone saves you in situations like this. I don't think being a paralegal saved me. What saved me was deciding on a specific Thursday morning with a highlighter in my hand that the numbers deserved a second look, and then actually giving them one. That's not a special skill. That's a choice. A quiet, unsexy, unglamorous choice to not accept what you've been handed without at least checking whether it's real. Sherry called what I was doing positioning myself for access to assets. She wasn't entirely wrong. I was positioning myself. Just not the way she meant. I was positioning myself to have the full picture before I made any irreversible decisions. That's all. It doesn't require courage, exactly. It requires the stubborn refusal to let someone else's urgency become your carelessness. My brother chose something different. He looked at our mother's illness and saw an opportunity, and he built toward it carefully, and the structure he built collapsed under its own dishonesty. The moment someone applied the slightest real pressure, that's not a moral lesson I feel comfortable delivering. He's my brother, and whatever he is now, he was also the person who taught me to ride a bike in a church parking lot in Burbank when I was 7 years old. I'm not in a position to reduce him to a villain, but I will say this. The choices we make when we think no one is watching are not invisible. They leave traces. They create records. And sometimes, the person you were counting on not to notice is precisely the person who notices everything.